Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand,
And I'm Matt Kaplan.
and today we have a really interesting topic that might be difficult to talk about, but is something that is very, very important because it affects every single parent out there. And it is how to handle estate planning when you have children.
And what's interesting is when you have children, there's a couple things that you need to consider, Kirsten. There is something happens to me, who's going to take care of my child, who's going to make decisions for them, but also something happens to me, what happens with the money or my assets going to my child? When does that happen? How does that happen? So with the first topic, Kirsten, just go into a little bit of, let's say I have a child, I pass away, I have nothing in place. With regards to taking care of my children, what does that look like?
So that's a really good question because the answer is going to be really similar to all of the other areas of estate planning, probate, guardianship. And that is if you don't make a decision about where it is your child should go, who should take care of your child physically and emotionally and mentally, then it is the state of Wisconsin that actually makes that decision for you. So what does that look like? Well, what it looks like is a big court proceeding. It starts out in children's court as a guardianship action. And then, for lack of a better term, it turns into something like a beauty contest. Various relatives can come from all different areas of the family, maybe even close friends, and anybody can petition the court to become a guardian, and then a guardian ad litem gets involved. A guardian ad litem is actually an attorney that is appointed by the court to represent the children before the court. So they're supposed to investigate and figure out what is in the best interest of the child. Now, you can just imagine what the issues with that might be, because the guardian ad litem has never met this family before. The guardian ad litem doesn't know who's honest, who's not, who has just recently pulled their life together, who has been stable for forever, who personality wise has fit with the child in the past, and who personality wise is just not a good fit for children. So there can be some real problems and mismatches that can occur, and some real fighting that can happen as well between all of the family members, because there can definitely be a groundswell of individuals who want to take the child or children, and there are some true nightmare stories out there. So that's what happens if the unforeseen occurs. And by the way, it has occurred. We've had at least 2 or 3 cases over the span of my career here at Hildebrand Law Firm where we have had both parents who have sadly passed away without any estate planning in place with minor children. And what ensues is, even if it's not as conflictual as maybe what I am saying, it absolutely involves so much stress and anxiety that otherwise could be alleviated by a very simple provision inside of a will that says, this is who I want to be the guardian of my children if that unforeseen event were to occur. And it's literally it's one sentence, and one sentence can change everything. And what I like to say to especially those of you who are in that category of people who maybe you have some assets but not a lot, and you're having children and you feel like, oh, really, I don't know if we want to go out and spend money on doing a big, huge estate plan at this point. You don't have to. If you come to Hildebrand Law Firm, we are very, very reasonably priced for a simple will. And that simple will, we can put the guardianship provision in there, and then that that is taken care of should that terrible thing occur. And I always like to say, I promise you, it's less than the cost of the stroller that you're going to buy for the child.
And now, Kirsten, is there any restrictions on who I can name in my will as to who's going to be guardian?
There are no restrictions whatsoever, and that is part of the point, is that the court and the guardian ad litem will have to look at things a lot differently if they're starting with no information than if they are starting with information. Now, if you happen to decide that you're going to appoint a dangerous person or a person with a criminal record to be the guardian, they're going to have to pass muster, if you will, in the court system no matter what. But you have now done your best to identify who that person is.
Well, that's fascinating, especially talking about, a lot of people come to me, especially I get a lot of young couples that come to me and they say, now that I'm a parent, that's the only thing that matters to me.
Right.
And I really want to make sure that my kids are taken care of. And the big thing of to take care of the kids, it's not so much the money, it's the who are they going to live with?
Right.
What decisions are going to be made on a daily basis? Which schools are they going to go to? What's their clothing? What is the activities they're going to participate in? All these decisions that you just subconsciously make as a parent, you need to put your trust in somebody else to carry out that legacy that you're trying to build for your child.
It truly is a monumental decision, and we strongly encourage all parents to at least have a will with a guardianship provision in it, because it is your voice then that is the one that is the most honored by the court system.
And so now that we talked a little bit about who's going to take care of your child and things like that, what are some other things that we should think about with regards to our minor children in our estate plan?
So now we turn to the issue of the money. And I will tell you a really sad story. So we had a situation where there was a local family, husband, wife, two young teenage kids. Husband and wife went off to Mexico to take a vacation, just the two of them, and they ended up getting into a terrible accident, and both of them were instantly killed. No estate planning in place, and because of the nature of the accident, there was a multi-million-dollar piece of litigation that ensued, and those two teenage kids were set to inherit a tremendous amount of money, millions of dollars. Because there was no trust that was set up, there was a minors trust that was set up with the court system. The money went in there, and then the court had to oversee all of the disbursements. That's not so bad. But what was really bad was that as of the age of 18, when they became adults, that's when that money was dispersed out to those kids. Now, who do you know at age 18 is ready to accept millions of dollars without any accountability whatsoever? This ended up being a major problem because those children had gone through a terrible trauma, and we could not even find one of the children because they had taken their money and gone off somewhere in California and literally had probably blown through all of it within a couple of years. The other child was doing somewhat better, but still not necessarily really proficient in being able to manage finances in an appropriate way. So what is the alternative to that?
So there's many alternatives, but my favorite alternative is take your money, put it in a trust. Have instructions in the trust that say, if anything happens to me, if anything happens to my spouse as well, I don't want my kids to have access to this money until they turn 25, 30. I had one client tell me 40. I don't want my kids to have access to money until they're married, they have a house, they have a career, stuff like that. I don't want them to rely on this. And so the wonderful thing about getting your estate planning done is that the state has rule books. The state rule book says 18, regardless, we don't care about the situation. Whereas if you get your own rule book done, you can put stipulations in there. They don't get anything until they turn 25. They don't get anything perhaps until they graduate from college or a trade school. Maybe they get a certain amount as a gift for graduation, maybe a certain amount as a gift for a wedding. My wife's grandma, when she passed away, she left a certain amount of money for her 3 grandchildren for each of their weddings. Thankfully, my brother-in-law paid for it on his own, and so we got his. But But you can stipulate all of that. That's your plan. And another big thing that I want to mention too, Kirsten, is a big thing that people say that they're scared about. We touched a little bit upon, certain issues that people can have in one of our previous videos. And the big thing with having your own estate planning in place is that you can say, give them the money when they turn 25 or when they turn 30, but only if everything is okay in their lives. If we don't have language like that, and if we don't rely on anything, if we just have in the situation like you talked about, where the day they turn 18, they get all that money, the bank releasing the funds does not care if at the time they turn 18, they're going through a tough time in their life. They're getting sued. They're filing for a bankruptcy. They're in a toxic relationship. They are, they have a horrible gambling, alcohol, drug dependency. Bank doesn't care. Bank is just giving them access, giving them the keys to the castle and saying, okay, good luck. Meanwhile, those two kids are those kids that you mentioned, they just grew up without parents.
And so this is where the role of the trustee really comes into play. And you, as the parent, have the ability to not only name who the guardian is going to be, but then also decide who the trustee is going to be, who is going to manage and oversee those funds, not only for purposes of investment and maintenance of those funds, but also for purposes of giving them the latitude to decide what is an appropriate expenditure. So it is not up to the child. Let's say we have a situation where the parents say age 25 is when the child can at the first time have full use and enjoyment of the funds. But it's really only if the trustee agrees that they're at that point in life where they're going to be responsible with those funds. If the trust is well written, it will have alternatives for the trustee, namely the ability to continue to hold back those funds until, let's say, a dark cloud has passed. For example, I know more than one person who got into credit card trouble in college and ended up having to do a bankruptcy. Well, that bankruptcy should be cleared before they get infused with money from a trust. Or let's suppose the 23-year-old, so it's 2 years before they're able to have full use and enjoyment of their funds, and they come knocking at the trustee's door and they say, I have this great idea. I want to invest in this company that's up and running. You wouldn't believe how I can get all of these people under me who then are going to pay for this potion that we're selling. And this potion is going to make me $1 million. All I need to do is invest $1,000 in this company, and I'm going to make $1 million while I'm sleeping.
It's not a pyramid scheme. I'm my own boss.
That's
it's totally
right.
fine.
That's right.
It's going to be great.
So I think everybody's heard of this.
Of course.
And probably everybody knows somebody who has gotten involved in something like this. And then now you look back in their basement and you can see 300 bottles of this potion that never got sold.
Right.
So this is the sort of thing that then the trustee can step in and say, I think we better use your money differently. And that is a really wonderful protection for your children.
Right. And even up until that age, or if, they're going through one of these events like that, the trustee still has the ability to give them money for the things that they might need. Maybe if they're going through a health issue and they need money to get health treatment. Maybe if they need money for college. Maybe if they need just certain money for support. I call it the necessities, but not the niceties. And what's great about that is that if you just go back to the scenario that Kirsten laid out with those two kids, that money sits in a bank account. Depending on the jurisdiction, you might not be able to touch that money unless you go and plead your case in front of a judge.
Right.
Depending on the jurisdiction.
Right.
And so if the kid's 17 and let's say you're a single mother and there's money in the account for a 17-year-old, or let's say, you really need access to the funds, unless you plead your case to the judge is not entitled to let you have that funds. Whereas if the money was held by a trustee, it's up to the trustee's discretion.
That's exactly right. Keeping it simple, right? That's what we're always aiming to do here at Hildebrand Law Firm. An ounce of protection, right, is worth so much, because then you're not getting yourself involved in these sorts of complexities. So thanks so much, everyone, for listening to this. And we are just always so interested in making sure that we are protecting your today and your tomorrow. Have a great rest of the day.